So we need to talk about what is now happening in response to the Supreme Court's recent denial of multiple assault weapon and magazine ban cases. So let's break down what is now happening. Now, before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you want to support the channel for free, one of the best ways to do that is just simply subscribing. Also, just double check to make sure YouTube has not unsubscribed you. And then also check out the newsletter that we have available. Links are down below. If you want to sign up, again, it's free. And then one of the things we're going to be doing is that once we reach 5,000 subscribers on the newsletter, we will be doing a monthly giveaway. So again, check those out. Links are down below. And thank you guys so much for all of your support. Now, as I mentioned in the intro, in this video, we need to talk about what is now happening in multiple cases which challenge the state of Illinois and their ban on so-called assault weapons and then also magazines. Recently, we received news from the Supreme Court during the end of their last term that in their order list, they denied review to all the Illinois rifle and magazine ban cases that were pending in front of them. In that order, only Justice Alito was interested in granting immediate review to all of those cases. But then also at the same time, we received a statement from Justice Thomas. That statement by Justice Thomas indicated that many of the justices believed that this topic of rifle bans and magazine bans is in fact very important, and that the Supreme Court needs to address this issue sooner rather than later. Now, from the order, it appeared that the majority of the court simply did not want to get involved in this case at this early stage because there was still some appeals going on. This was an appeal of a preliminary injunction that was denied, and instead what they wanted was a final merits decision. Now, you may remember that originally a lot of these cases were heard in front of lower courts, district courts who issued preliminary injunctions, but those are just simply temporary forms of relief. They're just initial blocks of the enforcement of the PICA there. Essentially just a temporary block on the rifle magazine ban. Now, Judge McGlynn was one of the judges most critical to that, and also Judge McGlynn has review of all these cases now. Now, Judge McGlynn outlined in his decision that he believed the plaintiffs were in fact likely to succeed on the merits of their claims, that essentially Illinois and their rifle magazine ban was a violation of the Second Amendment. However, the state of Illinois appealed that injunction, the preliminary injunction, up to the Seventh Circuit, and on review, a biased three-judge panel in the Seventh Circuit overruled the granting of that preliminary injunction. Now, again, in coming to that decision, the Seventh Circuit used an analysis that was incorrect. They relied heavily on the military use test, essentially saying that since they believe these AR-15s are useful in military service, the government here, the state of Illinois, could put whatever restrictions they wanted on them because they were dangerous and unusual items. And then there were multiple requests by all of these plaintiffs in these cases for the Seventh Circuit en banc panel to grant review and to review the denial of those preliminary injunctions. But the Seventh Circuit en banc panel denied review to all of those cases. That then led all these cases to seek immediate Supreme Court intervention on an interlocutory basis, essentially not review of a final merits decision, but a review of whether or not a preliminary injunction should be granted or not. But like I mentioned, the Supreme Court at the end of their term denied review to all the Illinois cases. Now, in that denial, Justice Thomas made a statement, and he stated that the state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. The AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. This court is rightly weary of taking cases in an interlocutory posture, but I hope we will consider the important issues presented by these petitions after the case reaches final judgment. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in DC v. Heller that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing the historical tradition of prohibiting the carrying of dangerous and unusual weapons. But this minimal guidance, according to Thomas, is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedent provides, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. He then goes on to say that the Seventh Circuit's contrived non-militaristic limitation on arms protected by the Second Amendment is in no way connected to both the text and history of the Second Amendment. And then he says, and even on its own terms, the Seventh Circuit's application of its definition is nonsensical. In my view, the Illinois ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. These petitions, he states, arise from a preliminary injunction, and the Seventh Circuit stressed that its merits analysis was merely a preliminary look at the subject. But he states, if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches us on a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So that is what Justice Thomas stated in the denial of all these orders, essentially denying review at an interlocutory posture of all these cases, and essentially leaving these cases in the hands of the lower court to reach a final merits decision. Now, like I stated, while these preliminary injunctions were being appealed and we're sending them to the Supreme Court for immediate intervention, there was all these cases also being developed at the lower court level in front of Judge McGlynn, who decided to essentially move these cases along to a final merits decision. Judge McGlynn held conferences on all of these PICA cases, and this was even before the Supreme Court was even issuing these order lists. And he said that no, he was not going to hold these cases. He was going to continue the conferences, continue the briefings, and move this towards a final merits decision. So that strategy played out well because Judge McGlynn was moving these cases along. There were some conference dates and some briefing dates that were set. One of the conference dates kind of got moved because the Supreme Court had pushed a bunch of the reviews of the PICA cases out, and we were waiting for the end of their term in the order list. So there was a little temporary halt just on one of the conferences. But then now, after the Supreme Court issued their order, all of these cases are proceeding forward at the lower court level. Most recently, last week, they held a video conference on all these cases. And again, they outlined that this is going to move towards a bench trial. And that bench trial and the evidentiary hearing is going to take place. And it's going to take place, I believe, on September 16th. So now that the Supreme Court has denied review to all these cases are going to move towards a final merits decision, a bench trial that's taking place on September 16th. So this year, there's going to be a hearing and arguments in front of the lower court judge. And then pretty fast, I assume he's going to issue his decision because Judge McGlynn has been pretty fast in issuing his opinions. So I would suspect that that's going to move forward pretty fast. But then, no matter what happens, we all know that either side is going to appeal that final merits decision up to the Seventh Circuit. And then the ball is really in the hands of the three-judge panel that gets assigned this case. Now, also very importantly, we're going to be keeping our eyes on the Duncan case, which deals with magazine bans. That's in front of an en banc panel in the Ninth Circuit and is set currently to be decided, although there is some arguments right now going on about what impact Rahimi has on that analysis. And then you also have the Bianchi rifle magazine ban case out in Maryland. That's in front of the Fourth Circuit. We're waiting for them to issue their decision as well. So there are two cases dealing with magazines and also rifles that are further along the process, final merits decisions that I would also suspect are probably going to be seeking petitions very soon to the Supreme Court. So for those in Illinois and those who have been tracking these rifle magazine ban cases, that's where this currently stands. There is still the hearing set for September 16th, a final merits decision, a bench trial on all these Illinois cases, and then they're going to proceed forward from there. So again, if you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.